Welcome to today's live session and panel discussion. I'm just going to wait for a couple of minutes for people to join in, and then we will begin. Yes, so I think we can begin. Welcome everyone to today's panel discussion hosted by Rest the Case. We are diving into one of the most debated legal questions of our time. Can secretly recorded conversations be used as evidence in court? And what cost to individual privacy? The Supreme Court's recent ruling has stirred an intense debate, particularly in the context of matrimonial disputes. In prioritizing the admissibility of evidence over the right to privacy, the ruling has opened new doors but also raised concerns about civil liberties and the potential for misuse and the very fabric of trust in person relationships. Joining us today are experienced legal minds who will unpack the legal interpretations, ethical dilemmas, and practical realities of the issue. So let's begin by setting the context and examining what the law currently says. I will quickly introduce our panelists today. So we have two of our panelists who are available here now. Two of them will be joining us later. So we have Advocate Vikas R. Sharma, who is the founder of Vikas Sharma and Associates, and an experienced litigator with over 15 years of experience in criminal, civil, and white-collar legal matters. His close work with investigation and prosecution branches of the Government of India gives him unique insight into the functioning of key government agencies. We also have Advocate Saurabh Sharma. With 2 decades of stellar legal experience, Advocate Sharma has earned accolades as a strategic legal expert. Under his leadership, JSSB Legal has been named Most Trusted Law Firm of the Year 2024. So, welcome to you, sir. Welcome to our panel discussion. Before we begin, I will request that I play a small video about Rest the Case, and then we will begin the discussion.
In a world where time is precious, getting swift access to legal help shouldn't be a privilege, but a right. Welcome to Rest the Case, India's most trusted online platform for legal solutions. We are transforming the legal tech landscape, bridging gaps, and bringing legal support to anyone, anywhere, at any time. The legal field in India can be overwhelming. Courts are crowded, the search for the right legal help is confusing, and legal fees can be unpredictable. Many litigants face trust issues, uncertain about finding a lawyer who truly understands their needs. Rest the Case solves this by providing verified lawyer profiles, making it easier than ever to find trusted legal support. That's where Rest the Case steps in. From consultations to document drafting and court representation, our digital platform brings legal expertise to your fingertips.
So our tools will make life simpler for litigants, retail, by helping them reach the right lawyers. We are using GenAI, we are creating an improved matching system. And for B2B, which is for startups and mid-level corporates, we are helping them by doing tasks like document draft creation, also other aspects which relates to their internal process improvement.
Powered by cutting-edge technology, our platform leverages AI to match users with the most suitable lawyers. Based on expertise and location, from its start, Rest the Case has grown rapidly. With a presence across India, our mission is to provide legal accessibility everywhere, from big cities to smaller towns.
Our vision is to make legal support accessible and affordable for everyone in India. Our journey began in the lockdown, where suddenly people did not know what to do or where to find the right legal support. We then realized that this is not just a pandemic issue. This is an issue that people face every day and everywhere. That's how Rest the Case was born. We bridged the gap between a lawyer and a client to give them a reliable place to find the right legal help.
Rest the case, because every case deserves.
Thank you for watching the video. So we will begin the discussion today by answering two by asking two questions. First is my question would be, what does the law currently say about recording in conversations and using that as evidence in court? Any one of you can take up that question.
So, good evening, everyone.
Hi, sir. Good evening.
So, this particular topic is, I guess, close to most of the litigants who are, embroiled in matrimonial issues nowadays, because this has been something which has been in grey, whether a recording which they are doing through their phone, or whether if they are recording something through the CCTV, whether it's going to be admissible in the court of law, because it's something which is going to, be in question, as it would be violating the privacy, right? So before Puttuswamy case is a landmark judgment when it comes to right to privacy. So Puttuswamy case in 2017 decided, in the case it was decided that privacy is a fundamental right under the Article 21. So all of a sudden, privacy becomes something which is at the heart of anybody's fundamental right. So if somebody, whether it's a husband or in-laws or anyone, is in breach of privacy, the particular person bringing something in the court of law may not be admissible, right? There were a lot of judgments where privacy particularly was, a concern, and hence admissibility was not, taken as a right in a particular matrimonial case. So this particular judgment of the Supreme Court, which has been delivered recently, has again brought privacy vis-a-vis, right to admissible evidence through modern gadgets, electronics, and all, right? So this is a debate whether truth has to be given more priority vis-a-vis privacy, or whether privacy has to be upheld as something which is unbreachable, right? So this is something which I guess the whole discussion would be around today.
Yeah, yeah, correct. So, Advocate Saurabh Sharma, then can you guide us through, the current ruling that has come out, where kind of admissibility of evidence was given priority over privacy? Do you think this is setting a dangerous precedent, or do you think this is just evolution of law as per the world we are in today, which is digital?
Hello everyone. The interesting part on the current topic is that this law was already prevalent in the courts. It is as a matter of course in most of the matrimonial matters and even otherwise. I have always advised my client, if they have any video or audio recording of their spouses and it can be produced as an evidence. There is an affidavit under, earlier it was 65B of the Indian Evidence Act. Now it is 63A, I guess, of the BSA. And if we attest an affidavit and prove the electronic document, it's already on record. It is admissible in evidence. There's nothing new that has come in this Supreme Court ruling. I don't know why it's in the news. It's already a law. It's already prevalent. It is already being used by most of my lawyers. So it's nothing new. It is already there, and it is admissible in law.
Right. I think it is the lack of knowledge of people which is
Probably, probably.
getting them to now be like, oh, is this okay or not? But then my question would be, where is the line in between right to privacy, respecting that, and bringing out what is true in court?
Look, the
How do we?
fundamental rights are always subject to reasonable restrictions.
Right.
If there is a right to privacy, the even otherwise the communication between a husband and wife is a privileged communication. But when the very basic, very basis of their relationship is in danger in a divorce proceedings, then why would someone not breach the privilege?
Correct.
it is quite obvious for him to produce an evidence by producing an electronic record
Hmm.
that supports his case. It makes all the sense.
Right. Advocate Vikas Sharma, what is your take on this? What do you
So
think?
basically, we'll have to understand why this whole thing is coming up right now.
Hmm.
Why it was not that prevalent earlier.
Hmm.
Why the question was not that important earlier. So basically, as we have experienced that in last 1.5 decades, electronic communication has evolved to a very significant and exponential level, right? We started from keypad phones where there was nothing, with regards to privacy, and then came up phones which could record us. Our rooms went from private to public. So basically, this is one thing where evolution has happened to a large level. Apart from this, we'll also have to understand that Section 122, where, as Sir said rightly, that the communication between a husband and a wife in a marriage is a privileged communication. So that particular section, the core of the section, the objective of the section was that the sanctity of marriage has to be preserved, you know, and at what cost? So Section 122 went to a certain level to ensure that that particular communication between a husband and a wife was secured and was not dragged into public and in court of laws. Now, why the reason why privacy, as we are discussing it right now, was not in question when these communications were brought in the court of law as evidence, because the fundamental right to privacy, which we hear it right now, which the Supreme Court has held in the judgment, which I was quoting, the Puthuswamy judgment, itself came in 2017. Prior to that judgment, there was a judgment, MP Sharma, I guess. In that judgment, it was clearly mentioned that privacy is not a fundamental right. So basically, there was always a doubt about it, whether privacy is a fundamental right or not. So Puthuswamy judgment just ensured that the question is correctly and finally closed. So now there is a lot of debate between whether privacy should be brought in or privacy can be breached in such cases where matrimonial disputes are there and where only certain type of evidences are present. Because if we go to any into any matrimonial dispute, the dispute between a wife and a husband normally happens in a bedroom, and then it drags down into the street and into the courts. So the evidences are also very private kind of evidences, and normally it is something in a manner of phone recording, video recording, CCTV recording. So this question has a very important origin, whether these evidences has to be admissible or not vis-a-vis privacy, because the privacy of the wife, the privacy of the husband, and the privileged communication under Section 122 all comes into question as soon as we bring these evidences into the court of law.
Yeah, exactly. So my next question then would be exactly this: is that okay? Evidence is allowed in court of law, and and recordings are admissible, but is this also taken into consideration that how that evidence has been obtained? Is that something that the court takes into consideration?
No, that is irrelevant.
Okay.
That is irrelevant because if suppose a wife or an husband is having an illicit affair and she has WhatsApp messages, and if the other spouse, in the absence of the person who is doing it, procures the messages and takes a printout and produces before the court, it is obviously against the consent of that person who is having the illicit affair. But since it is to be proven that he is not a person of right conduct, so that has to be admissible.
Right.
So basically, if we see the judgment which has come recently, the Honorable Supreme Court has pointed out two threefold test with regards to whether an evidence can be admissible or not. So the evidence which is going to be brought into court should have, number one, it should be relevant, it should be identifiable, and it should be accurate. So if any evidence passes through three tests of relevancy, identification, and accuracy, then it can be admissible.
Right. Do you think this is going to lead to a culture of where say spouses are recording each other just so that in the future, if there is some chance of them wanting this evidence, then they should have that. Do you think this might be something that might be happening?
Well, I don't think this judgment would trigger anything of that sort. It has already been prevalent in the society since ages. There have been cases where people have hired private detectives to find out whether their other spouse has been having an illicit affair or not. So it's nothing new. It will not come as a cultural shock. It's not that people will start installing CCTV cameras in their bedrooms to find out what the other person is doing or something of that sort. uh, if there's a trust in a relationship, obviously, if the trust is broken, then a person has to push the envelope and procure such evidences. I mean,
Right.
if the what I mean is that if the marriage is already at the threshold of being broken,
Yeah.
it is only then a person takes such drastic steps.
Yeah, that is true. Um, and in your experience, both of your experiences, have you seen such evidence being used where it was either helpful or not helpful? If you can
Yes, yes,
tell me.
yes. I have told you there have been various instances. There was a
Yeah.
case where a wife was exchanging her obscene images with a boyfriend, and those images, obviously in a sealed envelope, were produced before the court, and they were admissible in the evidence, and divorce was obtained on that ground.
Yes, that's true. And almost every day, I believe that these kind of cases come up to the court, and court grants relief to the other party based on what the evidences are. So,
Right.
but one thing I would like to add is that, as sir said, that it won't be changing the whole scenario, but what we can always say based on experience is that there was always a doubt in the mind of the husband or the wife that whether whatever I'm recording is going to be okay in the court of law or whether I will be held against it, right? So this judgment, because nowadays everything is on the social media, so this judgment would be going to the public at large, and
Right.
public would be educated about this particular thing, that if you are right and if you are being held as a victim of such a marriage where you are abused daily, you can always secure the truth with the help of modern devices, right? And the
Right.
same would be admissible in the court of law. So it's basically a constitutional balance which has been drawn between privacy and truth.
Correct. And what about other countries? How do other countries treat this, or what is their stance on privacy and using recorded conversations in the court of law? If you can give me
As far as
example.
my knowledge goes, it has always been admissible in other countries as well.
Right.
Recordings and WhatsApp messages and whatever sort of electronic records. It has
Yeah.
always been admissible in matrimonial disputes.
Okay.
So in most democratic setup,
Yeah.
always see one thing, that all the courts endeavor to have a balance between privacy and uh, uh, and this kind of recordings and all
Yeah.
brought up as evidence. So basically, truth versus privacy, which I will say. And if you talk about US have several states. So in different states, there are different laws.
Yeah.
Some states hold up privacy to such an extent that you can't bring up this kind of evidences,
Hmm.
right, without the consent of the other party. So it depends from state to state. But the point is that in any democratic setup, it has to be, accepted that there has to be a golden mean, a balance between both the things.
Right. Right. Right.
Look,
So.
if you would recall the famous case of Johnny Depp's divorce,
Yeah.
it's already
Yeah.
over OTT now, and
Yeah.
it's the most prominent case where electronic records were used to
That
prove.
is true. That is true. And the whole hearing in itself was so publicly available
Yes,
to
yes, yes,
everyone.
yes, 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 yes. It was a
Nothing.
media trial more
Yeah,
than
it was.
the judicial trial. Yeah.
That is true. But do you think that the matrimonial aspect of it complicates these recorded evidences being used, or do you think it is as simple as using it as evidence in any other case?
I would say the latter part is true.
Okay.
It's as easy and simple as being used, because for a lawyer, any case is equal. I
Yeah.
mean, yeah, because if we have to prove a case, the
Hmm.
best relevant fact has to be produced before the court. What
Hmm.
is relevant has to be proven. Yeah, because in the absence of such an evidence, how will you prove the relevant fact? So whatever evidence is relevant to prove an issue in our favor, we will have to bring it forward and produce it before.
Fair, yes. Do you think that there should be some
I
guidelines
think
or some?
Mr. Vikas had something to add
Yeah,
to
please, sir,
this.
please go ahead.
So please move forward with the question. I was going to answer the question which you're going to ask.
Okay.
Okay, all right.
So I was just asking, do you think there should be any guidelines or any kind of safeguards available where such evidences can be prevented from being presented in the court? Can this happen already? Like, can the other party put a request in front of the court to not use these evidences in court? Is that something that happens?
So nowadays, ma'am, as you'd be hearing a lot about deep fakes,
Yeah.
there are a lot of AI creations, deep fakes, etc.
Hmm.
And we will never know that if an evidence which has been brought in the court without adequate scrutiny, whether
Hmm.
the evidence has been doctored or not. So
Correct.
certainly there has to be guidelines.
Correct.
Number one, because of these technological reasons. Number two, also the guidelines have to be there, because if we don't, bring it to a stop to a certain level,
Hmm.
there would be also there will be a trend where people will be recording each other incessantly.
Hmm.
So a doubt will be there, and 24/7 recording would be there. This will bring a very, the whole institution of marriage into some kind of harm. So as a society, also apart from as a lawyer, we'll have to understand that privacy vis-a-vis truth have to be balanced.
Right, right.
It can't be that we are going to record each other incessantly and court is going to permit the same thing.
Yeah. Advocate Sharma.
That is the reason an affidavit under the 63A is required to say that the record has not been tampered with. It is
Hmm.
produced as it is, as it was recorded.
Yeah.
And what you said is also true. There are cases where injunction have been obtained
Hmm.
for restraining the other person to produce it before the court.
Right.
Maybe because stating that what my friend also said, that it is doctored, it is not produced as original. It was a very famous case of a senior lawyer in Delhi. I won't name him. And in that case, Honorable High Court had intervened and granted an objection, though it was
Hmm.
not a matrimonial dispute. It was something regarding something else. But yes, injunction can be obtained if the videography or the audio recording is a doctored one
Right,
or
right.
not true.
Correct. Now I want to ask a slightly tricky question per se. If someone is on the other side where they are going to, there is evidence against them going to be presented in the court, what advice would you say give them? What should they do, or what should their steps be?
If somebody is there who is going to the court of law and has something against him,
Yeah,
uh, in form of this kind of evidences, the first advice would be don't do something which is illegal and unjust to the other partner.
yeah. I
It
mean,
will solve the whole issue, because in
yes,
matrimonial issues it's not something in kind of a crime which you're doing, right?
yeah.
It's a crime, it's a private crime which you're doing against each other,
Hmm.
right? One party is going abusing the other party, and the other party is the victim.
Hmm.
So it's a very close kind of battle between
Hmm.
two parties, right?
Yeah,
It can be stopped by both the parties if the both party agrees to not abuse each other, right? So the first and foremost advice would be to have a just and equitable marriage.
right, right.
Well, if there is an incriminating evidence against my client,
Yeah,
I would first examine what's the nature of the act that is being depicted in that clip or audio
yeah.
recording,
Hmm.
and whether is it anyway going to harm our case
Hmm.
or not.
Hmm.
If it is irrelevant and doesn't harm our case to any extent, then obviously
Right,
we'll ignore it and let
right.
it pass.
Hmm.
But uh, uh, if I mean in matrimonial cases, the last resort is obviously a divorce by mutual consent in most of
Right.
the cases, which is the last resort and which is the last stage of every matrimonial case, because ultimately it all boils down to the alimony. And
Right.
it yeah, so I would say that that would be the last resort to the client.
Hmm.
And apart from that, as my learned friend also said, the first priority is settlement of the differences, reconciliation of their relationship.
Hmm.
That is the priority,
Hmm.
even if there is an evidence incriminating against my client. If
Right.
it can be patched up, even at the last stage of the case, our best effort is to let the two parties reconcile their differences and settle.
Yeah. Right. Even I think, I mean, in matrimonial disputes, the best way to resolve it is ideally not letting it reach the
Yes,
court of law, and maybe stopping it before that and reaching some kind of mediation,
yes, yes.
and sorting their issues out outside of court, which would be, I think, the fastest way to resolve it.
Well,
Um,
that calls for some other day of discussion.
yes, that is, I think, a whole
Yes,
new
yes,
discussion that we can have of mediation and
yes,
areas
yes,
in
yes,
matrimonial disputes, I
yes,
think. But yes, maybe that can be our next discussion that we have. um,
certainly.
but yes, so finally, then I would like to ask both of you: do you think that this ruling makes justice more accessible, or do you think it compromises on civil liberties of citizens in the long run? What is your take on it?
Well, in a very, I mean, in one sentence, I can say that it has put validation to production of electronic records as
Yeah.
evidence. Because otherwise, also, as I said, it was prevalent.
Hmm.
But now it has come in common knowledge and has been highlighted all over the media and
Yeah.
social media, and people have learned that such an evidence can be produced in their
Correct.
favor.
Correct.
That's where it has helped.
Right. Advocate Vikas, what would you like
I
to add?
believe that it's going to be a tool in the hands of people who have been, facing the victimhood till date, right?
Right.
Because we have seen a lot of cases where I would say that a particular gender, but nowadays it has been highlighted that a lot of cases, the one side, one
Yeah.
kind of gender has been facing the brute, right?
Hmm.
And a lot of suicides have been going on.
Hmm.
The reason which have been highlighted is that the code of laws generally hear one side and not hear the other side, right? So this kind of evidences would certainly put pressure on the both sides to understand this fact that if the truth is brought to the court and the court would be admitting the truth by way of these evidences,
Yeah.
and certainly justice would be done.
Correct.
So this is going to be a balancing act, I would say,
Yeah.
a better scenario until unless it's abused in some or the other way.
Fair. So I think we have answered almost all the questions that I had today. If anyone doesn't have anything to add, then I would like to end today's discussion. Does either of you want to add something to end it, to conclude today's discussion?
So
No, I think
one
we
thing,
have discussed. Yeah.
please go on.
Sorry to interrupt. Yeah, please continue.
So one thing which I would like to add, because the question came up,
Yeah.
that what strategy should be there. So nowadays, unfortunately, everything is about strategies
Hmm.
and not about the right party and the wrong party. But one thing which we can say after these kind of judgments is that if you want to win the case, you'll have to come with clean hands in the court.
Right.
Right? Anybody who is not coming with a clean hand in the court would be facing the ire of the court, because once the court comes to know that you're playing a fool of the court,
Yeah.
right, you are not going to get benefit from the court in any manner in a matrimonial dispute, whether it's alimony, whether it's maintenance, or anything else. And for those people who have been facing the whole music because of lack of this kind of evidences and all, it's a light at the end of the tunnel for
Hmm.
those kind of people. Now they can certainly, as they get educated, collect proofs of this
Yeah.
kind
Yeah.
and hopefully fight their cases to the best of their potential.
Correct. Correct. Right. Advocate Sharma, do you have anything to add?
No, I think we have had a very good
Yeah.
discussion on the topic and nothing remains uncovered now.
Yes,
Yeah.
I agree with you. So, I mean, to end this, I would just say that as lawyers, policymakers, and citizens, we have a responsibility to strike a balance between truth and privacy, truths and ethics, and law and humanity. I hope that this conversation helped everyone better understand not just what the law says, but what it actually means. Thank you again for tuning in. Thank you so much to our panelists. We had two other panelists who were supposed to join us, but unfortunately they couldn't join us. But nevertheless, thank you so much for the two of you to kind of take on this discussion and give us your insights. And I shall see you in the next one. Thank you so
Yeah,
much.
most
Have a good
welcome.
evening, everyone.